Legal battle is now brewing in the medical schemes industry over low-cost benefit options. The Board of Healthcare Funders is taking legal action against the Council for Medical Schemes. It wants the High Court in Pretoria to prohibit LCBOs. The Managing Director of the Board of Healthcare Funders, Dr. Katlego Mothudi, joins us now to discuss why. Doc, thank you so much for your time and good morning to you. Why this route? Why the legal route, of course, against the Council of Medical Schemes?
Morning, Jumelo, and thanks for having us. This route was taken really out of frustration over a process that has taken quite a long time. If you've been following the debate over low-cost benefit options, you'll realize that I think just over 7 years ago, there was a declaration and that went through to the court as a regulation, termed the demarcation regulations, that declared that no entity other than a medical scheme can provide services that are under law sanctioned for medical schemes. Now, at the time already, there were entities, mostly insurance houses, that were offering these primary care products to beneficiaries. And the courts then advised both the Department of Health and the CMS, or the Council for Medical Schemes, to put into place a framework that would see the transition of these beneficiaries from insurers to the medical scheme environment, to make sure that they are governed properly with the appropriate oversight by the CMS under the MSA. That process has not concluded. And I think the last straw was an extension over, I think in April, for the next 2 years to allow the council to still finish the process that has started over 7 years. Yeah. And this is after various interventions by the industry to even assist the council, participation in the advisory council, in the advisory committees, etc., to assist the council with the framework. We think it's unreasonable, and also it's unfair to the beneficiaries who cannot then access healthcare services that are available at the moment.
Yeah, Doc, I want to just touch on that unfairness. I mean, how are the current guidelines, in your view, almost infringing on the right to healthcare, but also to reasonable and rational legal guidelines?
So let me paint the picture a little bit there, Jumelo. Currently, there's just under 9 million beneficiaries who have got access to private healthcare through medical aids. We believe that medical aids are a credible participant in the healthcare sector, and they should assist government to relieve the burden that the state finds itself under. So over time, there has been various interventions to try and minimize the cost or lower the barriers for entry into the private sector. You'll be aware, for example, our attempts to review prescribed minimum benefits, which have for a large part been responsible for the escalating cost. You'll be aware as well that there was a commission that was set up by the department under the Competition Commission, Health Market Inquiry, that made similar recommendations to make or improve healthcare access. Now, what it means is that while you have about 9 million people enjoying, I would say, maybe better access in terms of availability through the private sector, you've got about 41 million people that are reliant solely on the state. We also seen that through Stats SA, a little over about 10 million people as well pay out of pocket. They are not linked to medical aids, but pay out of pocket and use private healthcare as their main point of contact. And we think that there could be further relief from the state on the state's overburdened status, as well as improving the access to these beneficiaries that are paying out of pocket anyway. And we thought that while we are reforming our healthcare system, the low-cost benefit option is a credible avenue to provide them another access to healthcare.
Yeah, and I understand that, Doc, as you speak, I mean, currently it's only insurance companies who offer health insurance products. However, medical aid schemes are prohibited from offering similar benefits.
That is true. This came after the enactment of the demarcation regulations. And at that time, those insurers that already had products in the market were allowed to continue to do so and that to allow the Council for Medical Schemes. And at that time, the initial period that was granted to the Council for Medical Schemes was only 2 years for them to craft the framework that would allow the transfer of these beneficiaries. Now, with that, there was also then a prohibition on schemes or any other entity to provide these services. We do believe, however, that the registrar has got the power to exempt schemes under what we call Regulation 8H that can allow schemes to participate as well. And this, we feel, prejudices members. You've got members of schemes that either because of affordability issues, downgrade their options, or some even leave schemes completely because they can simply not afford. And this could have been an avenue that they could have used. The second thing is that these products, because there's no oversight from the Council of Medical Schemes, some of them, even according to the Council for Medical Schemes itself, do not provide adequate cover for these services that people are paying for. The Council for Medical Schemes, I think about 3 or so years ago, released a report that showed that the claims ratio on these products are quite low. Some is low at about 30%, which we believe is not right for beneficiaries who are paying their money and not only get the right sort of access to healthcare.
Right. So just in closing, before I let you go then, Doc, just briefly just update us on where the status of the court battle is right now, what your stand is, because, I mean, from our conversation, I can hear that you're basically looking for almost, a progressive way, for both the public and private healthcare to, come together and, sort of address the challenges in our healthcare system. But in terms of this, court legal bid alone, what was your stand and what's the status of that court bid?
So the purpose really is to urge the Council for Medical Scheme to execute the mandate that is given to it under the Medical Schemes Act in terms of prioritizing the interests of the beneficiaries. Also, that it needs to align the sector to the departmental healthcare policies, and that we want them to increase access. What we seek and the prayers that we seek is that, one, there must be a lifting of the moratorium on schemes not to provide these benefits. We are by no way saying that insurers must stop, but rather there must be adequate oversight on these products. We are aware that the time is required to finalize this process. And we've actually asked the court that while, even if they rule in our favor, they must actually allow the Council for Medical Scheme a period of 12 months to implement these changes so that nobody is prejudiced, that people can still enjoy access to healthcare.
All right, well, we'll leave it there. I appreciate you speaking to us and updating us on the very latest coming from, of course, your side in the sector. Dr. Katlego Mothudi, Managing Director of the Board of Healthcare Funders of Southern Africa. Thanks for your time this morning.